Very good morning, everyone. Today we're starting the lecture number 7 for post-graduation program in export-import management. Today's topic is export sales contract. So what is this meaning of export sales contract? We will talking about the definitions when the buyers are sellers in different companies. As we know, because buyers belongs to different companies and sellers belongs to different companies. When they are making any contract for purchasing any product and services, for exchanging any product and services, that is called export sales contract. So what are the characteristics of export sales contract? The subject of the contract have been business established registered in two different countries and two different companies. Foreign currencies used in a payment could be either or both sides. The subject of the sale contract delivered out of the seller country during the contract performance. So what are the characteristics of? First, that both the parties have set up in two different countries, and both the parties have the different companies also. And while talking about the export sales contract, we have to use the certain foreign currencies for making the payments. Subject of the sale contract delivered out of the seller country during the contract performance. We have made certain classifications on the basis of in terms of performance period, that is called short-term contract and long-term contract. In terms of export relations contained in the sales contract, export contract, import contract, temporary import for re-export contract, temporary import for re-import contract, and transshipment contract. In terms of contract form, there are three kind of contract: written contract, oral contract, and default contract. Now, if we will talk about the short-term contract, whatever the contract we are making for the very short-term period, that is called 3 months or 90 days or 45 days, within the 1 year, and whatever the contract we are making, the maximum time limit that is called 1 year, that is called short-term contract. Whenever the time limit is more than the 1 year, that might be called as a long-term contract. The risk involvement in a long-term contract is more high as compared to the short-term contract, because in a short-term turnover is very less, and the what we call duration of the contract is very limited. So within those particular contract and those particular time period, short-term contract has executed. So that is the thing. While talking about the risk involvement in a short-term contract, risk involvement is very less as compared to the long-term. In terms of the export contract, whatever the contract we are making for the export from one country to the other countries, in the same manner, whenever we are importing any goods from across the globe, that is called export contract. Temporary import for re-export contract, if suppose that contracts we are making for the temporary basis, that is called temporary contract for import or export. In 1980, India Convention allowed member countries to use these forms. Written contract, whatever the terms and conditions we have been written down in our paper, and accordingly we have to be or both the party has to sign on the particular contract, that is called written contract. Oral contract, orally we have been put it down. Default, whatever the default terms and conditions which is actually followed in the every types of businesses, that is called default contract. In India, international sale of goods must be made on the basis of written contract, or the form equivalent include telegram, telex, fax, data message, or other forms prescribed by the law. Written contract may be made in the various forms, such as it includes a written contract clearing stating the contents of buying and selling. Trading conditions have agreed upon the signed by both the parties. Both the parties has to sign on the agreement, because suppose that one party is offering certain terms and condition and another party is accepting those terms and condition, then it will become the agreement, then it will become the contract. If there will be enforceability of the law, then it will become the contract. And then in a contract, whatever the contract we are making in terms of the written contract, both the parties has to be signed on that particular agreement or contract. Includes several documents such as telegram and correspondence. Many articles and signatures of contracting parties. Many articles and signatures of contracting parties. Commodity, quantity, quality, price, shipment, payment, packing and marking list. Art, seventh. In that belongs to the buyer side actually. Warranty, penalty, insurance, claim, arbitration, and other terms and conditions that belongs to the seller side. Now I'll try to explain all the main articles and signatures of contracting parties one by one. Firstly, we are starting with the buyer side. Commodity. The commercial and technical name suppose that whenever we are making the any agreement, so what are the things we have to be include while making in the contract? These are the things: commodity, quantity, quality, price, shipment, payment, packing and marking are. In a commodity, commercial and technical name suppose that we are importing or exporting the automatic washing machine 350. So what things we have to be include in terms of the while making any contract? So in terms of the commodity, we have to be write down the commercial and technical name of the particular product and services. Here we are using the product that is called automatic washing machine. The commercial and technical name that is called automatic washing machine W350. Origin country where the product has manufactured, that is called origin country. Manufacturer name who actually have manufactured the product, that is called Whirlpool. The features of the product, that is called fully automatic. So while talking about the commodity, whatever the commodities classifications we are writing on in a contract, so commercial and technical name we can write down origin country, manufacturer name and feature of the product. Got it? Second, quality. Method to describe the quality of the commodities. Sample, standard, trademark, technical documents, amount of substance, natural weight, inspected and approved, present value of the money, description. So what are the method to describe the quality of the commodity for making any contract within the two parties? Samples. Sometimes we have to be send a sample to the importer. Suppose that you are importers is ordering the, suppose that more than 10,000 markers, suppose that. Okay, and then what we can do, we can send the sample of 5 copies. So the sample, also from the sample we also can check the quality of the product and services. Standard, whatever the quality standard we have to be fulfill those standard which is actually which actually allow in the certain countries. Suppose that the importer is asking about the ISO standard or BIS standard. So whatever the standard are in the demand in the market, we have to follow those standard. We cannot sell the commodity below than the standard. Okay, so whatever the standards are running in the market in a concerned country, we have to be fulfill those standard. Trademark, if any, otherwise there will be a misuse of intellectual property rights. So if suppose that you have certain trademark. Trademark is all about that symbol, that logo we are using for a particular brand and product and services. Technical documents, suppose that if any, amount of substance, natural weight of particular product, inspected and approved. If the product is inspected by a certain government agencies or not, what are the present value of the money of the product and services, and the description. Got it? So these are the method to describe the quality of the commodity: the sample, the standard, the trademark, the technical document, the amount of substance, what are the amount of substance in a natural weight of the product and services, inspected and approved. If suppose that few countries are asking the inspected product only, you are demanding only those product which is actually inspected and approved by the government authorities. So we have to go for the inspection and approval of those product and services, whatever we are exporting from one country to the respective other countries. Present value of the money and descriptions. Then quantity. Identify the unit and weight. How many units we have? How many units and weight we have? Weight and how much weight? How much weight product have? These two questions raises in our mind while talking about the quantity. How many units we have? Methods of identifying the quantity and types of it. So while talking about the quantity, we have to be see how many quantities. Is it millions, is it 10 lakh or 1 lakh or 2 lakh or 3 lakh or 10,000 and 20,000. We have to be identify those units, and what are the weights of those particular units, then types of weight. Okay, so these three things we have to be check. These three things we have to be include while talking about, while making the contract, while making the export sale contract. Fourth is the price. Currency of price, whether it's in a domestic currency or internationally accepted currency, that is called internationally accepted currency. Which currency that is called accepted in across the globe? That is called US dollar, not dollar, US dollar, because is dollar is in a numerous number of the countries. So you Canadian dollar we have, Australian dollar we have. So while talking about the which currency which is accepted in across the globe, that is called US dollar. So firstly we have to be see whether the price in a your domestic currency. Suppose that India is exporting the product from India to India to Japan. So product is in a Indian currency, that is called INR, or in a US dollar. So currency of the price we have to we have to be see. Method of identifying the price: fixed price, deferred price, or revisable price. Terms of sale. What are the terms and conditions we have? Terms and condition key where terms and condition key terms and condition is like this: key how much payment you have to be made in advance once you receive a product, and after how many days you are going to make the payment. So whatever the terms and condition we are writing down here, so we have to be include all those terms and condition while making the export contract. Okay, because once the export will be done, and after that you are changing your terms and condition, it will chances of conflict will be very arises. So that is the thing what we actually we do. Whenever we just want to be make any export sales contract, we should include each and everything, and in each and every terms and condition, whatever the terms and condition we have. So method of identifying the price, whether we have fixed price or deferred price or revisable price. Then delivery, time of delivery, place of delivery, how much time you have, means importer you have, how much time you have. Yeah, how many days you are requiring, in how many days you are going to deliver the product and services. So in a time of delivery, whether it is 9 to 5, whether it's after 30 days, after 45 days, after 65 days. Place of delivery, it's Delhi, it's in India. So where in India? It's in Mumbai port, or Gujarat, or Calcutta, or Cochin, or Vizag, or wherever it is, or Delhi, or Lucknow. It depends actually. The place of delivery we have to be tell. So while making the contract, we have to be disclose each and every element of the quantity, quality, price, delivery, notification of delivery. When we get the notification of delivery, so time of delivery, place of delivery, notification of delivery. Then delivery, other remark, parcel shipment, allowed or not. Suppose that other remark parcel, if the shipment is parcel, allowed or not allowed. Not allowed, then total shipment. The allowed, then parties should decide who will bear the additional cost arising from the parcel shipment. Normally party requiring the parcel shipment. Normally parties, whatever the parties requiring the parcel shipment, they have to be pay the cost. Transshipment, allowed or prohibited. Okay, if suppose that other remarks, if suppose that shipment is coming in the partially, then what will happen? Allowed or not allowed? If not allowed, then total shipment we should not allowed. If suppose it be allowed, then who will be pay? Yeah, who will bear the additional cost arising from the parcel shipment? Normally, what actually happened in the normal cases, all those parties who actually requiring the parcel shipment, they have to be paid the certain cost. Then payment, currency of payment, US dollar, or Japanese yen, or British pound, or Indian rupees. So depending on, we have to be very careful, and we have to be disclosed very in a very advance. Whatever the currencies we are following, whatever the currencies we are going to accept, we have to be write down those currencies in an export sales contract. Time of payment, whether it's a 90 days or 30 days or 365 days. So whatever the time of payment we have to be disclosed in a export sales contract. because as we know there is a in terms of the foreign exchange it could be the currency appreciation or currency depreciation. That is the thing. What is all about the currency appreciation, currency depreciation? $1 is equal to 50 rupees. That is called normal price. If suppose it $1 is equal to 60 rupees, 60 INR, or $1 is equal to 40. We will talk about as per the Indian perspective. If your $1 became the 60 rupees, then Indian currencies got depreciated in terms of the dollar. If it went down the 40 rupees, then Indian currency got appreciated as compared to the US dollar. So in a certain period of time, it might get depreciated also, it might get appreciated also. So we have to be disclose the time of the payment also, method of the payment, whether it's a draft or RTGS, NEFT, SWIFT, or bills of exchange. In a bills of exchange, we have the side bill, we have essence bill. I have told you each and everything. Draft. Okay, so we have a numerous number of method of payment. We have to be disclosed in an export sales contract while making, whether it's a RTGS or a draft or NEFT or SWIFT or whatever the bills of exchange. It's a side bill or sense bill. But we have to be priorly informed in a what we call export sales contract. Then payment document, whatever the payment document, we have to provide those payment documents to the importers. Okay, so in a payment, I'll tell you this point once again. Let me complete first. In a payment, currency of payment and the amount of payment. Currency of importers country, currency of exporter countries or another country. So whenever we are making the sales contract, we have to be choose whether it's a currencies of importer countries. You are going to make the payment, suppose it in terms of India and Japan. In India, we use the INR, Indian rupees. In Japan, they have Indian yen. So if suppose that Japan is importing any goods and services from India, then whenever we are making the contract, whether we should use the INR or Japanese yen, currencies of importer country or currency of exporter countries. Another country, suppose that not even the Indian rupees, neither INR nor yen. We can make it the contract. We can make it the contract in a US dollar or British pound or European euro. Okay, got it. Time of payment. Actually, is it prepayment or payment in advance, side payment or deferred payment? You are making the payment in advance before reaching the cargo to the importers, or you are making the payment on the later on stage. That is called side payment. That is called immediate payment. Okay, so whatever the time of payment you are making, we have to be disclose those things while making the contract. Method of payment: mail transfer, telegraphic transfer, TT or DD. It can be bills of exchange also. Bills of exchange. Now bills of exchange, we have side draft, ascent side bill or ascent bill. Okay, so method of payment, in a method of payment, it can be remittance, can be import export contract terms. It could be the mail transfer, it could be the mail transfer, it could be telegraphic transfer, it could be demand draft. Okay, then documentary collection, import export contract sale, DP at site, DP at days after site date, documents against acceptance. Totally depends actually. Whatever you just want to put, you can include while making the import export contract. In a method of payment, we have types of LC, letter of credit. Letter of credit is an instrument actually. Date of opening the LC, issuing bank, advising bank and beneficiary. Issue date, expiry date, shipment. When you are making the payment, sometimes what actually we can do, we don't make the payment. Importer bank issue the letter of credit in the favor of exporters bank, and then what they do, exporters bank provide certain money to the exporters. So letter of credit is an instrument. It's just like a negotiable instrument. Letter of credit always issued by the importer bank actually. They take the guarantees on the behalf of the importer. Suppose that if anything will be happen, then importer bank will be responsible for Same. So time for advising the bank, notifying the seller, the LC. Seller accept the LC. Seller means exporter. Time for preparing the commodities. Sometimes what we do, we have issued the letter of credit before making any shipment. In a payment, further we have mean of production, shipping document are necessary for the settlement of payment, bill of lading, packing list, commercial invoice, insurance policy, insurance certificate, certificate of quantity and weight, certificate of origin, certificate of quality. These all documents I have been already described in lecture number 6 or 6 or 7. So you can watch those. You have already watched those videos. So in a payment, we have to be include. We have to be consider these many documents. Bill of lading, it's very compulsory. It's very most important document. Packing list, commercial invoice, insurance policy, insurance certificate, certificate of quantity, certificate of origin, and certificate of quality. Next, packing and marking. In a packing and marking, the specification should be clear. Packing plays a very vital role in terms of the international business, because on the basis of the packing we can charge certain higher prices also for the same quality, and for the same quantity, for the same goods and services. But the packing should be very attractive, packing should be very safe, packing should be very catchy actually. The sellers shall be responsible for any damage of the goods that may be caused by poor packing. Yes. Suppose that just because of poor packaging, if product will be got damages, then seller or exporter will be the responsible for the same. Packing and marking. In a further, marking should be in a permanent paint with a recognized kind of mark, meet shipping regulations. Whatever the shipping regulations we have to be fulfill those shipping regulation at any cost. If suppose that they are saying, depending on the product and product, depending on the services, we have to be make that customized packaging. Suppose that in case of the perishable items, we have to be use some certain what we call cold storage type of containers. So it totally depends actually. So whatever the shipping regulations, whatever the shipping requirements we have, we should follow those shipping regulations and shipping requirement. Ensure the proper handling of the product and services or product. Help receiver identify shipment. We should put it down certain marks so importer can recognize their product and services, like this fragile, handle with care, don't freeze. If suppose that cold storage is not required, so we should not freeze those product and services. Don't roll, don't distake, use no hooks. So that is the thing we can put it down these symbols. So product should be very product should be handled by really in a very proper manner. So these are the things we can put it down. These are the marks we can put it down in a container. Okay, you can see fragile, handle with care, don't freeze, use no hooks, don't distract, don't roll. Okay. Clear? Marking should be very permanent paint with the recognized kind of the mark. So if suppose that importer, because in a bun ship, so you are dispatching, you are exporting the product by the ship. Mode of transport, you are using the sea route. So in a bun sea, in a bun ship, there is a numerous number of containers kept there. You have put it down your product in a bun container. So once your container will be reached out at the importer place, so importer easily can recognize their product and services just because of those marks, just because of those what we call tattoos or some certain permanent certain what we call logos you have put it down. Then warranty. Next, warranty period. So these all many things we have to be put it down in an export sales contract. Okay. Warranty terms and condition. The manufacturer warranty to the quality of the solar module. The manufacturer warrant the solar modules to be free from defects in material and workmanship under the normal application. Installation, usage, service condition. If the solar modules fails to conform to the this warranty, then for a period ending 60 months from the date of the sale to the original end customer. The manufacturer at its option either repair or replacement or refund. The refund the purchase rise as paid by the customer. The manufacturer guarantee output power of the PV module is more than 25% of the minimum peak power within the 10-year and more than 50% in a 25 year. If can't reach the warranty data, the manufacturer will replace such losses in a power either by replacing the defective PV models or by refunding the purchase price. So whatever the warranties, whatever that I put it down one example here. You can write down, you can note down, you can read out. So whatever the terms and conditions of the warranties, we have to be clearly mentioned. Ki suppose that you are giving the warranty for the 5 year. For the 3 year, you are giving the guarantee also. Ki if any defect will be, suppose that you are selling the washing machine. Let's suppose within the 3 year, if suppose that any defects will be come in your washing machine, we will exchange or refund your full money. But the, after 3 year and the next 2 year, if suppose that something will happen, then we'll provide you service, but we will not refund your product. We will not refund your money. Then we are providing certain warranties. So whatever the terms and conditions of the warranty, we have to be clearly mentioned in the export sales contract. You can read out these paragraph again. Okay. Warranty terms and condition clear. Whatever the terms and condition you just want to be give in terms of warranties, we have to be clearly mentions in export sales contract. So there should not be there should not be any conflict just because of the warranty period. Then penalties, if any, late delivery or non-delivery by any regions except for the force measures, late payment due to the regions of the buyers, delay of opening, cancellation of the contract. Suppose that you have made the contract within the buyers and sellers. Suppose that there is a late payment or late delivery, so whatever the penalty you just want to be imposed, you can put it down. You can write down while making the contract. Okay. Suppose that anything will be happen, if suppose that being an importer have paid suppose that 50 lakh rupees to the importer, and you for 50 lakh rupees to the importer, for that you have to be send the marker by the 10th of June. Suppose that if the and if you will not be able to supposed to send the delivery of the particular markers to by the 10th of June, then you have to be pay the penalty of rupees 1 lakh rupees per day. If suppose that you are making the you are delivering after 10 days or 20 days, then you have to be pay the you have to pay the concern amount whatever the penalty has been imposed to you. So late delivery, late payment due to the regions of the buyers, it is in case of the both. If suppose that there is a late payment by the buyers or late delivery by the sellers. Then insurance documents, insurance policies, insurance certificate, combined certificate, open policy or open cover. In an insurance policies, it should be clearly mentions what is all about the insurance, what are the things we have to be included in insurance policies, what are the claims we have, and what are the maximum limit of the claim, how much insurance company has to be pay in case of any casualties. Okay. Then insurance certificate should be provided, combined certificate, and open policy and open cover. So these whatever the insurance terms and conditions, we have to be write down, we have to be put it down in export sales contract. Got it? Then force majeure. Force majeure is an event that can be neither anticipated nor reduce the control. A seller can avoid his contractual obligation without paying a compensation or penalty. In case force majeure is all about due to some external factors, if seller is not able to send the product to the importer, so there will not be any penalty by the sellers. Claim. On the basis of terms and conditions of the contract, condition and warranty, material breaches and the minor breaches. On the basis of consequences of the breaches of contract. We suppose that on the basis of terms and conditions of the contract, we suppose that whatever the terms and conditions we have been write down in an export contract, we suppose that there is a breaches of those contract. So what will happen? There is certain conditions which we have to be fulfilled at any cost, and we have to be pay the cost for the warranties also. In the same cases, if suppose your contract has breaches due to the any reasons, then we have to be see whether it's a material breaches or the minor breaches. Main point, claim process we have to be see how much amount we have to be pay, rights and obligation of the two parties, what are the right and obligation of the parties A, that is called buyers, right and obligation of the parties B, that is called seller. So we have to be see the right and obligation of the both the parties. Accordingly we will make it out the decisions. Method to adjust the claim. Then arbitration. Arbitration is a consensual dispute method. It allows disputing parties to have a neutral party to assist them in arriving at a solution. I have already told you in a second or third lecture about the arbitration. Arbitration is all about to resolve the dispute without any legal help. So arbitration is a consensual dispute method. It allows disputing parties to have a neutral parties, because the third parties will be come with you. Third parties we have to be involved the third parties who is having some expertise to resolve those dispute. Okay, solving their problem without courts or law, that is called arbitration. Arbitration articles shall be stipulated. Applicable laws, place of arbitration, who shall bear the arbitration cost, whether the buyers or seller. It's totally depending on the condition to condition, whether the breaches of the contract by the buyers or sellers. Accordingly we have to be see, accordingly arbitration cost has to be paid by the buyers or sellers. Thank you so much once again. Thank you so much for joining. Take care. Suppose that anyone is having any doubt, they may ask. So again, I am just telling you from the very first PPT what we have covered today. We have started from here, export sale contract definition I have been told. Then classification in terms of performance period, that is called short term for the less than 1 year, long term is more than 1 year. In terms of business relations content in a sale contract, export contract or import contract, temporary import for re-export contract or temporary import for re-import contract, transshipment contract. In terms of contract form, there are three kinds of contract: written contract, oral contract, or default contract. Written contract may be made in a various form ways, such as include a written contract clearly stating the content of buying, selling. Trading conditions have been agreed upon and signed by both the parties. Both the parties has to be signed on the particular agreement. Then main articles and signatures of the contracting party. For the buyer side and for the seller side. Buyer side we have commodities, quantity, quality, price, shipment, payment, packing and marking list. As per the seller side, warranty we have to be give, we have to be impose the penalties, we have to be pay the penalties also. We can make it out the insurance just because of to coverage of risk, claim, arbitrations. In a commodities, in a commodity, what can be included in a export sales contract? Commodities, the commercial technical name of the particular product and services, origin country, manufacturer name, features of product. In quality, we have to be see the sample, the standard, the trademark, technical document, amount of substance, natural weight, inspected and approved, present value of the money, description. Quantity, how many units we have, identify units and weight, method of identifying quantity and types of weight. The price, currency of price, method of identifying price, terms of sale, fixed price, deferred price and revisable price. Then delivery, how much time you have, time of delivery, place of delivery and notification of delivery. Delivery, other remark, parcel shipment, payment, currency of payment, time of payment, method of payment and payment documents. Payments, currency of payment and the amount of payment. Payments, method of payment, remittance, import export contracts. Payments, method of payments, mean of production, what are the documents we have to be include for settlement of payment, bill of lading, packing list, commercial invoice, insurance policy, insurance certificate. Then packing and marking, warranties, penalties, insurance documents, insurance policy, insurance certificate, combined certificate, open policy, open cover, force majeure, claim, arbitration. That is all about your today's lecture. Thank you. Take care.